We'll start with closing arguments and the state. Mr. Tiffin.
As the judge told you in the instructions, what I have to say right now, what Mr. Hart has to say on behalf of his client is not evidence, they're arguments. Evidence finished yesterday afternoon when Mr. Mattioli left the witness stand. It began Tuesday morning when Mr. Peters took the witness stand. Everything that happened between those 2 points in time, what people said, what you heard, what you saw, that's the evidence. You take the evidence, you take the law which the judge writes to you, and you have to make decisions. You have to decide whether or not the state has proven beyond a reasonable doubt whether Mr. Mattioli committed a crime and or whether or not his conduct was privileged. You know that Mr. Mattioli is charged with first-degree reckless homicide. That's simply a label the legislature chose to put on the crime. What's important is how they're defined. This is just a chart. You won't have this chart, but you'll have these words in the jury instructions. First-degree reckless homicide. We'll also have a choice of second-degree reckless homicide. As instructed are degrees of homicide. They share certain elements in common, and the state has to prove them. One, that the defendant caused the death of Joe Acevedo. Cause means that the defendant's actions were a substantial factor. It doesn't require the state to prove that they are the only factor. They have to be a substantial factor. In this case, you know this. On the morning of April 19th, Joe Acevedo was walking, was talking, was moving, and was alive. When Robert Roach walked into that kitchen, Mr. Acevedo, his brain, didn't have sufficient oxygen. He was essentially pulseless and non-breathing. But for the paramedics resuscitating a pulse, he would have died there. He died 6 days later. What's the difference between those 2 points in time? Mr. Mattioli being on his back. Was Mr. Mattioli's arm around Joe Acevedo's neck a substantial factor? We'll never know because Joel can't tell you. I mean, I know Dr. Jensen takes the position there was no definitive pathological evidence of significant compression. Those were his words. That's true because there were no broken bones, there were no injuries to the muscles. That doesn't mean there was not some compression. And in fact, when being interviewed by Investigator Dallin, Mr. Mattioli's words were, "I didn't press hard enough." By saying I didn't press hard enough, it implies there was some pressure there. But what we do know is that you can get petechial hemorrhages. You can prevent oxygen from getting to the brain by being on the back of a person and crushing their thorax, their chest. And that's what Mr. Mattioli did. Andrew Janowski acknowledged that he told the police that Joe Acevedo had Mr. Mattioli's weight on his back. Dr. Jensen, Dr. Tlomak both said that action responsible for the lack of oxygen that caused the anorexic encephalopathy, the lack of oxygen to the brain. Officer Roach, who walks in, who's not intoxicated, sees this and sees Mr. Mattioli is not crouching just sort of lightly. His weight is on Mr. Mattioli's back. The conduct of Mr. Mattioli that morning was a substantial factor. Was it the only factor? No. but it was a substantial factor. But for Mr. Mattioli's conduct, Mr. Acevedo would be alive. First-degree reckless homicide and second-degree reckless homicide also require the state to prove that the conduct was criminally reckless. Criminally reckless conduct means conduct, as stated here, and it's in the instruction. It is conduct which creates a risk of death or grave bodily harm to another person. The risk of death or grave bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created that risk. What you have in this situation, you have to look at everything that happened. You have a picture of an extremely angry man, Mr. Mattioli. That is obvious from the 911 call and his statements. You have a man who is intoxicated. You have a man who gets on the back of Mr. Acevedo when there was no apparent struggle and remains there. In fact, when the police pull up, the words out of Christopher Peters' mouth are, "We have him subdued in there." There's no struggle going on at that time. Mr. Peters has left. He stood outside. He's smoking a cigarette. He knows that he's already subdued. Does Mr. Mattioli get off? No. He remains on his back. He stays there and holds him down. And you know, to Investigator Dallin, Mr. Mattioli says, "I knew he was breathing." That shows an awareness that what you're doing creates a substantial and unreasonable risk of death or grave bodily harm. But what does he say to Officer Roach when asked, "Is he breathing?" "I don't know." He wasn't paying attention to what he was doing, even though he was aware of what he was doing created this risk. The 911 call, the body camera of Officer Roach, the picture you see is a man, Mr. Mattioli, who's angry, who's intoxicated, who has restrained and prevented Joel Acevedo from getting up, who didn't pay attention to what he was doing. And he was just on there. And there was no sign he was going to get up until the officer said, "Get off him." He had to say it a couple of times, "Get off him, officer." And as he's getting up, he sort of pushes off. He would have stayed there for who knows how long. And he knew what he was doing. He knew it was dangerous because he said so, but he wasn't acting to pay attention to the person he had restrained. That is criminally reckless conduct. Did the conduct show utter disregard for life? That is a factor question. In determining whether the conduct, the circumstances of the conduct show utter disregard for life, you consider factors. You can consider, I'll simply read it. These factors, what the defendant was doing, why the defendant was engaged in the conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances. Did Mr. Mattioli's conduct show any regard for the life of Joel Acevedo? In the back of that squad car to Investigator Dallin, his words were, when told he's in bad shape, Mr. Mattioli said, "I don't give a fuck what shape he's in." That's an acknowledgement. You don't care. You have no regard for the life of the person you've just restrained, for the life of the person who's held, for the life of the person you're relying on. There's no regard for what was going on. His conduct was not only criminally reckless, but it showed utter disregard for life. It is the state's view that the elements of first-degree reckless homicide were committed by Mr. Mattioli. You also, though, have to consider as the judge instructed you. These issues. Because on the evidence, these issues are there, and the state has the burden of proving that these are not applicable. You have to consider self-defense. You have to consider defense of others. You have to consider arrest. You have to consider an accident. Now, this was not an accident. That's simple. An accident would be Mr. Mattioli tripping and falling on Mr. Acevedo, maybe hitting his head and not being able to get up. That's an accident. These were volitional acts of Mr. Mattioli getting on Mr. Acevedo. It's not an accident. Under Wisconsin law, a person can use force in self-defense or defense of others if the defendant believed there was an actual or imminent interference with his person and person of another. The interference on this evidence happened. It happened in that living room. The push, there was the hit. But then it's done. Self-defense doesn't let you then restrain a person for however long you want to. In fact, the words spoken by Mr. Acevedo when the 911 call is made are these: "Let me go home. My score's not woke. I'm going home." Shortly thereafter, "I swear I'll go home. I swear." Okay. There's no longer any threat going on. Mr. Acevedo wants to leave. He wants to get out of there. And he's prevented from getting out there by Mr. Mattioli, who's simply angry. You hear that in the 911 call. Just anger. I mean, you saw a version of Mr. Mattioli on the stand yesterday. You saw and heard a different version on April 19th. That's the version that's important. It's not the version that's had 3.5 years to think about this. That morning, this was not, "I'm in trouble, we're protecting him." This was simply anger to hold him down. This was not self-defense or defense of Mr. Peters. It's also not a legal arrest. First of all, you don't make an arrest when you're intoxicated. And second of all, when you arrest somebody, you're responsible for them. You have to watch out and make certain they're okay. That was not done by Mr. Mattioli. As he said, he didn't care what shape he's in. Simply didn't care. His actions were not reasonable. The defenses of self-defense, defense of others, reasonable lawful arrest and action are not applicable. Now, as I said, there are two versions of Mr. Mattioli. There's a version you saw and the version then. You have to decide what happened that morning. What happened that morning was a man who's extremely angry, and his conduct is a substantial factor in causing the death of Joel Acevedo. His conduct was criminally reckless and showed utter disregard for the life of the person who was restrained. And based upon the evidence, the state asks you to find him guilty of first-degree reckless homicide. Thank you.
Thank you. The defense, Mr. Hart.
Thank you, Your Honor.
Thank you.
Please, the court. Mr. Tiffin. Good morning, ladies and gentlemen. When you took an oath to serve as jurors in this case, and when we talked in jury selection about following the law, you all assured me and the process that if selected as jurors in this case, you would take the evidence as presented in the courtroom, apply it to the law as instructed you by Judge Swanson, and then and only then reach a just and true verdict. If you apply that law, as you've sworn an oath to do, you must find Michael Mattioli not guilty of both first-degree reckless homicide of Joel Acevedo and second-degree reckless homicide of Joel Acevedo. The facts in this trial are largely uncontroverted. You heard them from Mr. Peters, you heard them from Mr. Janowski, you heard them from Mr. Mattioli first when he told Investigator Dallin, and you heard them again live from Mr. Mattioli yesterday. In large part, each one of those stories is consistent, and the state hasn't provided any evidence to the contrary. On April 18th, 2020, Mr. Mattioli was at his home, in his own home, after inviting some of his friends to come over and sit by the fire. After an evening of partying and drinking to excess, to be sure, they all did the responsible thing and remained at Mr. Mattioli's home rather than get in an automobile. And Mr. Mattioli went upstairs and went to bed. You heard Mr. Tiffin just tell you that there were two versions of Mr. Mattioli. The version you heard on the tape and speaking to Investigator Dallin, and the Michael Mattioli you heard on the witness stand yesterday. I would submit that there are two versions of Joel Acevedo. The Joel Acevedo who came over to Mr. Mattioli's house at Mr. Mattioli's invitation. The Joel Acevedo that Mr. Mattioli befriended when the two of them were working at Northwestern Mutual Life. And contrast that with the cocaine-fueled, alcohol-fueled, aggressive Joel Acevedo that comes into Mr. Mattioli's bedroom and begins rifling through his pockets. Later, in an agitated way downstairs, strikes Mr. Mattioli first, then punches Mr. Peters in the face so loud that it popped and knocked Mr. Peters down the hall. That's a different Joel Acevedo than Mr. Mattioli had ever seen before, ever. The only difference between Mr. Acevedo the previous night and the next morning, we learned from Dr. Valentine, who tells you, based on his review of the toxicology reports and the urine and blood of Mr. Acevedo taken at St. Luke's Hospital the next day, there was high levels of cocaine metabolite running through his veins. And when Mr. Tiffin tells you that but for the conduct of Mr. Mattioli, Mr. Acevedo would be alive, think of it the other way. And that is, but for the conduct of Mr. Acevedo, Mr. Acevedo would be alive. Because Mr. Mattioli was having a party in his own home, inviting his friends over. He didn't ask for any of this. Mr. Mattioli didn't attack Mr. Acevedo until Mr. Acevedo attacked Mr. Mattioli and Mr. Peters. And what he did is defended them in his own home. This isn't a street fight. This isn't a fight Mr. Mattioli picked with as a bully. He's in bed minding his own business. When in comes Mr. Acevedo rummaging through his pockets. What? What are you, really? Mr. Mattioli tells him, what's going on? No, it's not what you think, Mr. Acevedo says. Well, your hand is in my pocket and I'm asleep. What else am I to think? You need to leave. You need to leave. You, sir, need to leave. This nonsense about Mr. Acevedo says, I want to leave. He wants to leave after he's punched two people and he knows he's about to be arrested. Yeah, I'm sure he wanted to leave. The time to do that had come and gone. And now you're going to have to leave in police custody because you committed a crime, at least one, probably more. That's this case. And so when we talk about reasonableness and self-defense and the right to arrest, all that exists. And the law, as instructed you by Judge Swanson, tells you. Mr. Mattioli, in his own home, has the lawful right to defend himself. He has the lawful right to defend his guests. He has the lawful right to arrest someone who's violated the law. And the judge told you that. And with respect to your decision, the law says, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Joel Acevedo by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life, which I'll argue in a moment, and the death of Mr. Acevedo was not an accident, which I'll get to, and that the defendant did not act in self-defense, and that the defendant did not act lawfully in defense of others, and that the defendant did not act lawfully in using force to make an arrest. You must find all of those things did not occur beyond a reasonable doubt in order for you to convict Mr. Mattioli of either charge. Go through that. Go through that analysis. But before you get there, you need to decide as a primary matter, did Michael Mattioli cause the death of Joel Acevedo? Did he cause it? And on that issue, you heard from Dr. Jensen. Dr. Jensen is a credentialed forensic pathologist that provided testimony from Mr. Tiffin's office for 20 years or better, in hundreds, if not thousands of cases, after conducting 5,000 or 6,000 autopsies. He is eminently qualified to render opinions on cause and manner of death. And he told you on the issue of what caused Mr. Acevedo's death the following. Mr. Acevedo died as a result of prone restraint, being on his stomach and being restrained by Mr. Mattioli, which is inherently safe in healthy individuals. Let me repeat that, because that is a critical opinion by Dr. Jensen. Prone restraint is an inherently safe maneuver in healthy individuals. The literature supports it, and his experience tells him that is true. He concluded, but for the conditions, Mr. Acevedo's obesity, Mr. Acevedo's smoking, Mr. Acevedo's cocaine, Mr. Acevedo's immunoglobulin deficiencies, which reduced his ability to fight infections, and the violent struggle with Mr. Mattioli, that is what caused his death. But for all of those things, Mr. Acevedo is still alive, is the opinion of the eminent forensic medical examiner in this trial. Uncontroverted testimony, uncontroverted. He would have survived, says Dr. Jensen, but for obesity, smoking, cocaine, immunoglobulin deficiency, and violent struggle. And so, when Mr. Tiffin tells you in his opening statement, you will have to decide, was this an accident or was this criminally reckless conduct? think about Dr. Jensen's testimony on the issue of cause. And in terms of accident, Mr. Tiffin tells you it was a volitional act. It wasn't some by chance accident. No, the accident was the death. This was an accidental death. It wasn't an accidental encounter with Mr. Mattioli. It resulted in an accidental death based upon Mr. Acevedo's own conduct in striking Mr. Peters. That's the case. That's the case. And before you can find otherwise, you must be satisfied, beyond a reasonable doubt, that the state has proven it wasn't self-defense, it wasn't defense of others, it wasn't an accidental death, and Mr. Mattioli caused the death of Mr. Acevedo. You must make all of those findings beyond a reasonable doubt. The law also says, as Judge Swanson read to you, under the burden of proof in deciding whether Mr. Tiffin has proven his case beyond a reasonable doubt, if you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so. What does that mean? Is it a reasonable hypothesis that a man of 25 years old with the most compromised lungs Dr. Pearl, the pulmonologist, almost has ever seen? These were severely compromised lungs. He had bad disease. There were moments in the last 2 or 3 years of his life where he was pushing out 24% of the oxygen necessary to keep him alive. He was compromised in a way very few others are. Mr. Mattioli had no idea of the lung compromise of Mr. Acevedo and how sick of a man he was. And so when you think about reasonableness and recklessness, Mr. Mattioli had no idea about the depths of Mr. Acevedo's lung condition. According to Dr. Pearl, his lung function was pretty awful. Those are Dr. Pearl's words. Asthmatics are already at a higher risk of infection. You were told that. And that the exercise or exertion can make a person with compromised lung disease at a significantly higher risk. According to Dr. Pearl, it is a matter of life or death. That's who Joel Acevedo was when he began lashing out and punching people in Mr. Mattioli's home. On the reasonable hypothesis, is it possible that these severely compromised lungs, coupled with the use and abuse of cocaine, the use and abuse of alcohol, the use and abuse of cigarettes, and the struggle with Mr. Mattioli brought about his death accidentally? The death was an accident. And you must find, in order to convict Mr. Mattioli, that the state has proven beyond a reasonable doubt that it wasn't. That Mr. Mattioli should have known of the badly scarred and compromised lungs of Mr. Acevedo. He couldn't possibly have known that. I don't really know what to tell you about Dr. Tolomac, except that she concedes that as a person with severely compromised lungs, Mr. Acevedo was more vulnerable than the average person. She finally conceded that. I know this about Dr. Tolomac. She didn't author a report. She reviewed the work. of the pathologist, the medical examiner, Dr. Peterson, and ultimately she viewed some slides. She tells us that in her opinion, Mr. Acevedo suffered from neck compression. You heard from Dr. Jensen, there is no objective evidence to support that claim, none. So as you think about credibility, you'll have to think about Dr. Tolomak, who didn't author an opinion, didn't author a report, and Dr. Jensen, who's eminently qualified. Dr. Jensen tells you there is no objective evidence to support a claim that he suffered any deprivation, that he suffered any significant neck suppression that would cut off his airway or cut off oxygen to the brain. That's what Dr. Jensen told you about the neck compression issue. He also told you that the petechiae about Mr. Acevedo's body was a shawl on his arms, on his upper chest and his thoracic region, which were indicative of chest and abdominal compression. Dr. Jensen tells you that Mr. Acevedo was medically frail, that he suffered from severe pulmonary compromise. He explained to you what ought to be obvious to most, that cocaine increases heart rate and blood pressure. That's the man who Mr. Mattioli encountered in his living room that day. A severely compromised and medically frail Mr. Acevedo, and he couldn't possibly have known it. He couldn't possibly. Dr. Jensen tells you that even with some amount of weight on the back, that the prone restraint is inherently safe, and that ultimately the cause of Mr. Acevedo's death was cardiac arrest. His heart gave out. His heart gave out because it was beating too fast from the cocaine, likely. His lungs gave out because it was severely compromised and occluded, as Dr. Kroll showed you in the diagram. It was occluded with infection that probably wasn't properly managed because he hadn't been getting these immunoglobulin shots back in 2019. And he had been involved in a violent struggle of his own making. There are no winners in this case. This is a tragedy beyond imagination. But the cause of it, and ultimately the cause of Mr. Acevedo's tragic death, was his own conduct. And Mike Mattioli didn't ask for any of it. Those are just the simple, hard facts. Mr. Mattioli acted reasonably. He acted lawfully. And he acted appropriately. His behavior after the fact, something different. But whether he was boorish, rude, obscene, vulgar, in speaking with Investigator Dallin for those 5 minutes after he was stewing in a car for 4 or 5 hours, that isn't part of your analysis. Those aren't the facts related to Mr. Acevedo's tragic death, or the law which governs your deliberations on whether a criminal act occurred or an accidental death occurred. And it would be more than a shame if you allowed Mr. Mattioli's boorish speech to Investigator Dallin to govern your ultimate decision in this case. Whether this was an accidental death or a crime is not even close. There are at least 4 reasons why the state has failed miserably to satisfy its burden beyond a reasonable doubt. I've laid them out for you. You've paid attention over the course of this week, and on behalf of Mr. Powell and Mr. Mattioli, we appreciate your willingness to serve. I'm asking, based on the law you are duty-bound to follow, that you return verdicts of not guilty on the first-degree reckless homicide charge, as well as the second-degree reckless homicide charge. And in closing, I will say this. You and I, the judge, we all have the right to defend ourselves, perhaps the duty to defend our guests in our own home. That's what Mr. Mattioli did on the 18th and 19th. He didn't punch Mr. Acevedo, he didn't kick Mr. Acevedo, he didn't shoot Mr. Acevedo. His conduct was eminently reasonable and appropriate, and I would ask that you so find. Thank you.
Thank you. Mr. Tiffin?
I agree with Attorney Hart in this respect. His client's behavior with Mr. Dallin in the car should not be a reason to convict Mr. Mattioli. What's important is the words he said, not his behavior. The words he said, I'm told this guy's not in good shape. I don't care. There was no thought about what he did. That would be. The words that are important and the tone of the words in the 911 call shows a person not acting reasonably in self-defense, which will arrest him. It shows an angry who's not going to listen either. And yes, Mr. Acevedo had all these conditions, but he had them for a while. It didn't prevent him from going to pub crawls. It didn't prevent him from working. It didn't prevent him from going to the party. It didn't prevent him from getting Mr. Peters. Mr. Hart talked about all that, but ignored one thing that's important. His client climbing on his back and crushing his face. Can't forget that. That's all part of the picture. I agree with facts in this case. Are largely disputed. You have to decide whether or not state in the case there is reasonable cause. The state simply asks you to take the evidence, all of the evidence, take the law. And based upon this, it's the state's position you should be found guilty of the first degree reckless homicide. Thank you.
Thank you. Great. Ladies and gentlemen, now, final closing instruction. Members of the jury, the duties of counsel in the court have been performed. This case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind, and as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 3 forms of verdict will be submitted to you concerning the charge against the defendant, Michael A. Mattioli. 1 reading. We, the jury, find the defendant, Michael A. Mattioli, not guilty. Another reading. We, the jury, find the defendant, Michael A. Mattioli, guilty of first-degree reckless homicide as charged in the information. And the third reading, we, the jury, find the defendant, Michael A. Mattioli, guilty of second-degree reckless homicide as charged in violation of Section 940.06 of the Criminal Code of Wisconsin at the time and place charged in the information. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. You will be taking this binder with you back into deliberations. The verdict forms are under tab 1. These instructions are under tab 2. Again, remember, just execute one of the 3 forms of verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff, signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should consider and continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict.